Good afternoon for the final 15th presentation. I'm very glad that you are still in this room. I will try to be rather brief to follow Beate's example. I do hope very strongly that the entire version will be published soon, as all the other papers. And maybe I will be a little bit controversial. I do need the remote. There it is. Company law implies various rules that force the management either to inform voluntary or on request. The German Stock Corporation Act, like many others, states that each shareholder shall upon a request be provided with information only at the shareholders' meeting by the management board regarding the company's affairs, and only to the extent that such information is necessary to permit a proper evaluation of the relevant item on the agenda. To put it another way, if a topic is not on the agenda, there is no access to information at all. The German Corporate Governance Code provides detailed provisions on disclosure, especially in the context of transparency and on reporting and auditing. But are almost no mandatory provisions about disclosure in the field of corporate social responsibility. Nevertheless, more than half of the German corporations are committed in CSR. A survey of 2013 has stated that CSR communication exercises substantial influence over corporate reputation, you can see the numbers on the slide, employee relation, stakeholder relations, and customer relations as well. In contrast, the relevance for shareholder value can be neglected. The impact for the stock price is quoted 1.2%. The CSR directive of the European Union has been adopted. One may discuss whether it is an appropriate approach to justify the directive with the primary aim to increase investors' trust as well as consumer trust. But nevertheless, national law has to comply with the European CSR directive by December 6 this year. One may also be skeptical what will be the benefit of a provision which expressly confesses not to provide a distinct guideline but allows, I quote, highly flexibility in action in order to take account of the multidimensional nature of corporate social responsibility and the diversity of CSR policies. Until today, nobody may imagine what can be understood by a sufficient level of comparability that meets the needs of stakeholders as well as the needs to provide consumers with easy access to information on the impact of businesses and society. It does not improve matters that the EU Commission has to prepare non-binding guidelines on the methodology for reporting non-financial information by end of this year. Three key issues of corporate law of relevance in the context of sustainability reporting. First, the importance of sustainability for the interest of the enterprise. Second, the struggle between soft law and hard law. And third, the challenge of law enforcement. All topics we have heard of already. Number one, the interest of the enterprise. It is widely accepted that different information systems exist within corporate law. On the one hand, there exists a wide range of disclosure and information rights which only members of a company may exercise. These are reciprocal rights and obligations instead of simple collectible debts of the shareholder. But it is true that more and more the management board has to act on its own initiative. On the other hand, external stakeholders have to be informed as well. These are not only employees, clients or creditors. A variety of obligations concerning reporting of financial matters is available as well as only exists in the interest of investors or, in general, the public. That leads to the question whether there exists just one unique company interest or completely different and potentially opposing, whether spheres of interest have to be balanced. The German Corporate Governance Code recognizes the interest of the enterprise as the indemnity of its continued existence and its sustainable creation of value in conformity with the principles of social market economy. The code as well states that the interests of the shareholders, its employees, and other stakeholders have to be taken in account. Therefore, the public interest has to be considered, but it cannot outweigh the main objective of the company. Number two, sustainability. It's mentioned only once in the German Stock Corporation Act. The provision deals with the remuneration system of listed companies that shall be geared towards the company's sustainable development. In this context, the code speaks about the objective of sustainable creation of value, or in other words, the enhancement of the company's long-term value. But this seems to be a total different approach as it is intended by the European initiative. The material scope of the CSR directive covers the disclosure of non-financial and diversity information. And number three, both aspects together. Traditionally, Traditionally, the corporate interest cannot be simply equated with shareholder value. From this perspective, sustainability has also the meaning of the indemnity of the continued existence. In this regard, the criteria of this directive may be crucial, but this is not compulsory. Moreover, the European legislation can be regarded as an attempt to overweigh the public interest in contrast to private interests. Or in other words, to abolish the interest of the enterprise and to replace it by an incomprehensible or, if you like, all-encompassing public interest, whatever that means in this context. There we are, the fourth slide. Today there already exists a wide range of international, multinational, and national regulations, as for example soft law like non-binding principles, we have spoken about it, or hard law in written or unwritten form, and on top a vast numbers of standards, regulations for anything. The origin may be traced back to the Lex Mercatoria, definitely binding rules in due course. But what are all those good for? Hadn't an honest merchant of former times known himself what to do or what to omit? Germany, meanwhile, has an extensive experience in the transformation from soft to hard corporate law, starting with a definitely voluntary and non-binding corporate governance initiative decades ago. Since 2002, there exists recommendations of the Government Commission German Corporate Governance Code, published by the Federal Ministry of Justice in the official part of the Federal Law Gazette. Matthias has mentioned that. The code gives recommendations and suggestions that reflect the best practice of corporate governance. But it is far more than that. On several occasions, the code has been used as a pattern for a legislative reform, or at least as a source of legal interpretation of the Stock Corporation Act. This is a good example for how the borders between soft and hard law become blurred. Since decades, there also exist several standards for compliance management systems. What can be said about all these legal sources? There is no doubt about the need for corporate governance codes, especially for large undertakings, which depend on the capital market, but there is a requirement for structures and principles concerning the distribution of rights between the stakeholders of the corporation, and particularly their duties and responsibilities. Compliance as well can be useful, and it is primarily beneficial for the corporation itself and also of interest of the directors. The consequence, sometimes I have the impression that today nobody does bother about the question what one is justified to do. The entity just addresses a lawyer and buys a CMS of the pack. The question is then whether a CMS can work like a carte blanche and prove that the entity and the directors have done everything that could be achieved. then they may wash their hands of it. Such insurance policies sell like hotcakes. But natural choice is neglected. That is the vital requirement for developing and teaching a real company culture. And what's about CSR? In the beginning, this has been a voluntary undertaking. Today, it seems to become a semi-mandatory one in the context of immense reporting requirements. Since 2011, the new European definition states CSR as a responsibility of enterprises for their impacts on society. Can this seem as a paradigm shift? And will the results be more than just another marketing instrument, or will it be all for nothing? However, from the perspective of expenditure, it can be expected that in practical implementation, no serious problems will arise. Auditors have already put together huge packages. Periodical auditing will generate permanent earnings. But who will have to pay for it in the end? There are two options, and both are disappointing. Corporations have the choice to raise the price for the product and bill the consumer. Or they look to the other end of the chain, and that means that the price has to be paid by the workers in the form of low labor conditions and minimum wages. Concerning the legal approach, some thoughts. The European legislator has decided against an implementation of social responsibility in the material company law. I think that is your approach to change the material company law, not these soft law. There is and there will be no specific duty of directors and members of supervisory board to exercise specific measures. As always, there are several options how to transpose a directive, and especially this directive, into national law. These different options, opt-out clauses and other means of minimum harmonization, make it to some extent soft law for the member states, but not for their corporations. The German Ministry of Justice, for instance, has released a concept for the implementation of the CSR directive, but that does not exceed a reform of the management report, as already indicated by the headline. And concerning law enforcement, the question is, what are adequate and effective means to guarantee disclosure of non-financial information by undertakings, and how can these be enforced? The concept of the directive raises this issue and states as a result that at least the auditor has to check the existence of non-financial and diversity information. That may provide ample food for thought and gives reason to discuss a means for enforcement of adequate information. A provision is only of effect when it is respected. Therefore, it needs compliance. At the first stage, auditing is necessary. Secondly, compulsory measures are required. As far as soft law is concerned, the latter does not come into question, which, with the exception of elements of social pressure. And who will be able to induce compliance? Specific fines for failure to comply with the standards of CSR have not been determined under the European corporate law. Specific criteria how to interpret sustainability still do not exist. That's why it is very difficult to make sustainability litigable. And I already come to my conclusion. The scope of the interest of the enterprise today is one of the most exciting questions in company law. Dealing with the rights or just the status of internal and external stakeholders, there will always be the need to distinguish both objectively and personally. Boundaries have to be drawn that are not universally valid. In this context, the topic of sustainability symbolizes a special challenge. No other field of comparable public interest. The difficulty to come to a solution and to give a definition of the various spheres of interest is clearly demonstrated by the European directive, which seems to be inconsistent in many ways and is difficult to implement in practical application as well. But one should not misinterpret the directive as a fundamental determination concerning corporate law. And more hard law in this field will neither be an effective way to ensuring the corporations act responsibly and adhere to good corporate governance principles, nor really improve corporate governance practice significantly. On the contrary, an increasing regulatory density may have the effect of limiting the options for moral behavior. So just take it as it is today, another European compromise and a nice declaration of intent that will produce no more than enormous cost and much ado. Thank you. 3 minutes for discussion.
Very efficient. German. Any questions?
Yes, thank you for a very interesting presentation. Sorry. Yes, thank you for your presentation. I wondered, when you say that more hard law will not be effective here, do you mean that in the sense that just adding more reporting requirements in the legislation will not be effective, or do you mean generally that there is no hope in legal reform?
I meant it in this way concerning the aim of the European initiative, not in general, not in general.
Good.
Of course, law reforms are of effect, but you have also to keep the costs in mind. That is what you have already mentioned.
Totally agree.
Comments, questions?
Just with regard to your cost point, you list 2 possible payers of the cost, consumers and employees. Why are those the only 2 who could pay? You could reduce management pay, you could reduce returns to shareholders, you could, in other words, those are not the only 2 sources of the money that, or the financial acumen, that resources.
Yeah, you are completely right, but I come from Germany, and you know, we have Volkswagen, and maybe you have read that nothing was reduced, but there is a scandal. The company looks what is the easiest way to do it, and I gave 2 points. That is my small experience, how the world talks.
I feel that's quite interesting when you refer to the stats on CSR and the effect that it has. I mean, it clearly has quite a positive effect on consumers, employees, reputational risks, and so on. But the impact of CSR on shareholder value, as you've shown, is obviously very low. So what is the relevance? Do you think the conclusion can then be drawn that the relevance of CSR is only for other stakeholders, not for shareholders? Or is it an indirect impact maybe on shareholders?
I would agree. It is indirect, and it's not to measure. They have asked several stakeholders. By this survey, we do not know whom they have asked. In the end, you have always to be very careful with you yourself do surveys. But I think, in general, that will be true. That for the general aspect and for the shareholder value, it's not of direct influence, but of course it will have indirect reflections.
Not, it's sort of question, but not a question. It's sort of a comment.
So I relaxed.
Sorry. I was just interested to follow up what Kent had said. I mean, just by way of a case study, it might be very quick, I won't go into it, but in 1983, I think it was, some Tylenol, which is a drug in the US, a painkiller, was infected and caused the deaths of a number of people in the States. I think it started off in Chicago. And Johnson & Johnson had a number of decisions to make, the company. And what they did was they basically pulled all the Tylenol off the shelves so no one could buy it. And it cost them millions and millions of dollars and reduced dividends. Most people regard what they did was responsible. It was, you know, it was socially responsible action. But it didn't lead to a reduction in labour amounts, so the number of people employed. It didn't lead to a higher cost for customers, but it did reduce the dividends. So I'm just wondering if that could not be a way forward that could be taken, because effectively we know from the long term Johnson & Johnson did prosper. They bounced back, and in the long term it was a good action, in the sense that the long term interests of the company were satisfied. So I'm just thinking that maybe the reduction of dividend that could come from that is a way forward possibly to address the issue. So it's a sort of a comment, but you might want to make a comment back on that, or Kent might want to come back on it or not.
Well, sure, but nobody can be sure that that will happen.
No.
And we have a lot of examples. I think we had this in the motor industry. We had it with Toyota, and they did something else, and their brand is now very good because people know that they care for this, and there could be a chance for Volkswagen as well. But smaller companies will not see the advantage of this, and will look where they get the money back.
Yeah. I suppose we're thinking of the big companies,
Yeah.
big public companies.
Can I just do a jumping off point from Andrew's comment? And that is, you said that there's only an indirect relationship between CSR and the effect on shareholders. But I mean, the point that he raised is about risk minimization, and that has a direct effect. And there's been many instances in which, if you had anticipated the risk and minimized those risks, it would cost you less to have taken those issues into account ex ante rather than ex post.
In the long run.
Also in the short run, I mean, as you can see from Johnson & Johnson,
Yeah,
you know,
yeah.
had they done things properly before, those children wouldn't have died, their profits wouldn't have been affected in the short run as well as in the long run.
Well, it depends on the dimension and what the damages are. Sure.
Can I just those spills weren't the problem. Johnson & Johnson was responsible. Somebody actually had. Not bad. They had actually been affected by some wrongdoers.
But so that's just, I mean, that's an example. But the thing is, they could have put in greater compliance procedures for that to prevent that. I don't know anything
Yeah,
about
maybe.
that specific
I would-
example. But I mean, I do work in mining, and mining is all
Yeah.
about that.
I know that. I'm just making sure that we do badmouth big companies. I know, but in this
Okay,
case,
so
we probably
Johnson
could.
& Johnson is a good.
Well, not necessarily.
You realize that you are playing with my time.
Well, I actually wanted to go to that discussion as well, but I will direct it to you. that I'm not so sure that CSR, to use that term, needs to have any indirect effect even on returns to shareholders, because that depends totally on how that is followed up. And far too often, I think we've seen scandals where, surprisingly enough, the share price hasn't sunk and the dividends are still paid out. But perhaps we should be a little bit more creative. Perhaps we should think about, as a part of a larger legal reform, having some kind of conditions before business is allowed to pay out dividends. That they can't pay out dividends if they've been caught violating any laws the last business year, for example. I think we should try to be a bit more creative. That's just off the top of my head. Thank you. What do you think? Question?
Well, we have now the case of Volkswagen, and there is a direct connection also in the time frame, but mostly the disclosure of such damages and so on is a lot of years later, so the dividends are already paid.
Yeah. Can we hopefully just come with one final question? And is there anything positive that you can see that's been achieved from
To be honest, no.